Ladies and gentlemen, welcome to another episode of Law in the Limelight, where three entertainment attorneys, myself, Peter Speroni, Winton Yates, and Max Haas, all discuss current events and anything under the sun entertainment. Today's topic has been in the news for quite some time, and we thought it was really important to discuss this issue as it's applicable to the contracts in which an artist would contract with record labels or publishing companies and really have a good understanding of the copyrights and the music they create. And so today's topic is the issue of Taylor Swift and Big Machine Records. I'm sure you have all heard about it at this point. And today we'll be going over sort of the intricacies of a record label agreement as applicable to the masters, which we all know she will be re-recording, as well as the implications on the underlying lyrics, melody, and composition for the publishing pie of the copyright. And so I wanted to get started by giving a little bit of background here on the timeline and exactly what happened in the situation with Taylor Swift. And I'm going to refer over to Winton to give us a rundown of what we know up until this point. Winton?
Yeah, so it was in 2019 when Taylor Swift announced that she was going to start re-recording her catalog, and this came as kind of a big shock to everybody. But she kind of explained that she wanted to regain her artistic and financial control over her catalog because of this big deal that went down. So it was in 2019 that the music mogul Scooter Braun, who was kind of a character, got a hold of Taylor Swift's masters when his media holdings company Ithaca Holdings acquired Taylor's former record label, Big Machine Label Group, for a deal that was reported to be around a little bit over $300 million. In that deal, Taylor Swift's first 6 albums got swept up in that deal. So Scooter Braun got a hold of the masters to 6 of her early records. Arguably all classics in Swifties' eyes. So Swift and Scooter Braun have a super rocky relationship. Scooter Braun also does some stuff with Kanye West, and this was kind of around the time that Kanye and Taylor had their thing, and it was kind of out in the ether that Scooter Braun was the puppet master, kind of making that whole beef between Taylor Swift and Kanye happen. But around that time, on Tumblr, Taylor Swift posted about this $300 million deal. She was accusing Scooter Braun of being a bully and claimed that she didn't know about the deal until it was announced to the world. And then, just for some further context, Taylor signed with Big Machine Label Group back when she was 15, so she was like a kid. And she later left Big Machine for Universal Group, who's arguably the biggest label ever. And in an interview with CBS News, she explained that she walked away from Big Machine because she knew once she signed a new contract with Big Machine, Scott Borchetta, the big guy over there, was going to sell the label and thereby sell her future in all her records.
So the idea here would be she didn't want to go with Big Machine again, subject to the same sort of provisions that she had signed away for these first 5 albums before. She didn't want to do that with her new music, and was sort of looking at a new kind of structured record deal with Universal.
Yeah, she was kind of trying to avoid what happened, but it happened.
Yeah, and I think it's important. This is a perfect sort of segue into what I was mentioning earlier in regards to how sort of the copyright works in all of this, because it is important to say here for an artist like Taylor Swift, we are talking about, arguably one of the top artists at the top of the pop game. We will talk next week. Please tune into our episode where we're going to be going over these major acquisitions of these big catalogs and talking a little bit more nuance into some of the implications that may have on the record industry. So until next time, thanks for tuning in. I'm Peter.
I'm Winton.
I'm Max. And I'm Max.
Oh my God.
One of our rules is telling you about the other rules. First thing you should know is nothing we say here is legal advice. And shouldn't take it as legal advice. We'll be giving our personal thoughts and opinions on various entertainment industry issues, and we hope that it's informative and maybe even educational for you. But if you have a specific legal issue, then I recommend you contact an attorney directly and set up a consultation where they can give you legal advice. And the second thing you should know, even though we all work for the same firm, it doesn't mean that we all speak on behalf of our whole firm. The views and opinions expressed are solely our own. Final words of warning depends on what state you're in. While you're watching or listening, be aware that Law on the Limelight may be considered attorney advertising. And that's all I have for you today. I hope you enjoyed listening. So without further ado, please enjoy Law in the Limelight. Law in the Limelight. Please enjoy Law in the Limelight.